And welcome to everyone joining us for today's webinar. My name is Laura Dean. I studied my LLB at Brighton in the UK and have been working at Eltoma for just under 2 years now. I'm currently at the Limassol office in Cyprus today. So I'd like to draw your attention to the chat box on screen. So if something is unclear or you would like further clarification on anything mentioned today, please feel free to submit your questions and I'll be happy to elaborate, perhaps in the form of a Q&A section at the end, but this is time permitting, obviously. But I will reply to any unanswered questions via the email that you used to sign up today. And if you'd like more information about any judgment or ruling, looking at case law will give you a really in-depth explanation. So I've put the important cases in bold throughout the presentation, and I would recommend taking a note of them to look up later if you're interested. So today we'll be looking at a range of basic principles in UK company law, which can be applicable to most common law jurisdictions. So specifically the characteristics of a company, what it means for a company to have a separate legal entity, creditors' risks and how they can protect themselves, limited liability and what it means, corporate ownership of assets, how to effectively use offshore companies, lifting the corporate veil, so what it means and how it's relevant today, company formation and process of incorporation, as well as the advantages of incorporation, and the legal effect of continuation, and we'll also be looking quickly at company constitution, so documents such as memorandum and articles of association, company objects, so share capital, the issuance and transferal of shares as well. So the definition of a company is a group of persons who organize themselves to pursue a common objective or purpose that usually involves conducting trade for profit, conducting trade or business for profit. So a company as an entity has many distinct features which together make it a unique organization. The essential characteristics of a company are the following. So it must be a separate legal entity. So under incorporation law, a company becomes a separate legal entity compared to its members. So the company is distinct and different from its members in law. It has its own seal, its own name. Any assets and liabilities are separate and distinct from those of its members. Capable of owning property, incurring debt, borrowing money, employing people, owning a bank account, entering into contracts, suing and being sued separately. So this is essentially what is meant by having its own legal entity. As well, a company has a limited liability. So the liability of the members of the company is that also the members are also referred to as the shareholders of the company. So this means that it's limited to contribution of assets that each member has contributed up to the face value of shares that have been held by him. So a member may be liable to pay only the uncalled money due to shares held by him. And if the assets of the firm are not sufficient to pay the liabilities, then the creditors can then force the partners of a company to make the deficit up from any personal assets. However, this cannot be done in case of a company once the members have paid all their dues towards the shares held by them in the company. So as well, a company has perpetual succession. So this means that the company would not cease to exist unless it specifically wound up or the task for which it was formed has been completed. So membership of a company may it may keep going. So the even after one company has ended, perpetual succession just means that it will always be continuing unless it is struck off from the registrar. But we will look at this at a little bit more in depth later on. And this is all essentially wound up on UK Companies Act. A more recent act is the 2006 one. So there are many advantages to incorporating a company. So as we've already discussed these some of these points here, this is actually why many sole traders and partnerships tend to incorporate, because these actually are considered to be quite advantageous, especially as opposed to all of the rights that you have being a sole trader or only a partnership. So we will look again a little bit now at perpetual succession. So it's essentially when it's continued, a continuation of a corporation or other organization. It exists despite any sort of death or bankruptcy or change in membership, or an exit from the business, for instance, including any transfer of stock. So as we've already discussed as well, limited liability, and often you will see this abbreviated at the end of a company, just LTD. So this essentially means that liability is limited to the company. So in the event of the company going into liquidation, any debts remain with the shareholders of the company. Only to the extent of what they have invested or guaranteed to the company, as opposed to having any of their personal assets or funds having to be contributed in the event that the company winds up. So a number of other advantages of incorporating is that you may be able to raise capital more easily as a corporation than as a sole proprietor. So it's easier to transfer ownership in a corporation than it is in a sole proprietorship or partnership as well. You also have significant tax benefits, as the general corporate tax rates in most jurisdictions are significantly lower. If you have employees, incorporation can offer protection for any personal assets. So if someone that you're employing acts in a way that causes the company to be sued, obviously, yes, you wouldn't be personally liable for any of your employees' actions, as with this is opposed to with a partnership. Obviously, everyone in a partnership is considered equal, and obviously the liability will be a lot different with the partnership. So as well, you may be able to employ and retain good employees by offering them stocks or shares in the business. And as well, with incorporation, it opens access to many estate planning benefits. So we'll look a little bit more in depth again at what a separate legal entity entails. So essentially, it means that the business is accountable in its own right. So limited companies can legally own property, commence legal proceedings as if they were just an individual, own shares in other companies as per relevant company law. Companies can also claim the right to a fair trial, to freedom of expression, and to any property rights. We'll look now at Salomon and Salomon. This is a landmark UK company law case, and the effect of the Lord's unanimous ruling was to uphold firmly the doctrine of corporate personality, essentially upholding the right of the separate legal entity that we've just discussed. And this was set out in the Companies Act 1862, so that creditors of an insolvent company could not sue the company's shareholders to pay up any outstanding company debts. So we'll look a little bit at the details of the case now. So Mr. Aaron Salomon, he made leather boots in a shop. It was based in London, and his sons wanted to become business partners. So he turned the business from a sole trader into a limited company. The company purchased Mr. Salomon's business for £39,000, which at the time, see, was in the 1800s, it was an excessive price for its value. So Mr. Salomon's wife and 5 eldest children became shareholders. The 2 eldest sons also became directors, and Mr. Salomon took 20,001 of the company's 20,007 shares. So transfer of the business took place, and Mr. Salomon gave the company a £10,000 loan. This was secured by a floating charge over the assets of the company. This is also what we call a debenture. So on the security of his debentures, Mr. Salomon received an advance of £5,000 from a man named Edmund Broderick. And soon after Mr. Salomon incorporated his business, he experienced a decline in boot sales, exacerbated by a series of strikes led by the government. And Mr. Salomon's main customer split its contracts among more companies to avoid the risk of its few suppliers being affected negatively by the strikes. So unfortunately, Mr. Salomon's business failed, and he defaulted on his interest payments on the debentures. Obviously, half were being held by Mr. Broderick. Mr. Broderick sued to enforce his security, and the company went into liquidation. So Mr. Broderick was repaid his £5,000, and this left £1,055 of company assets remaining, which Mr. Salomon claimed would leave nothing for the unsecured creditors, of which £7,703 was still owing. When the company failed, the company's liquidator contended that the floating charge should not be honoured, and Mr. Salomon should be made personally responsible for the company's debts. Mr. Salomon obviously challenged this and sued. So the liquidator, on behalf of the company, counterclaimed, wanting the amounts paid to Mr. Salomon to be returned and all debentures cancelled. He argued that Mr. Salomon had breached his fiduciary duty for selling his business at an excessive price, and he also argued that the formation of the company as a result of this was fraudulent against its unsecured creditors. So the House of Lords overruled this, stating that the company was established validly, So the company was not an abuse of any legislation and should not be considered to be a sham. So as the company was held to be valid, Mr. Salomon obviously held a priority over this creditor. And essentially, this is enforcing the company as a separate legal entity. And an outcome of the case was a concept which we'll look at in a few slides. It's the Veil of Incorporation. So in the decades since Mr. Salomon's case, various exceptional circumstances have been defined both by legislature and judiciary in England. So when courts can legitimately disregard a company's separate legal personality, such as where a crime or fraud has been committed, obviously this concept of having a separate legal entity will not remain, and person has to repay any debts out of their own pocket, essentially, if the company has been created as a sham or with any malintent, essentially. So there is a lot of debate since this case as to whether the same decision would be reached if the same facts were considered in the modern legal environment. And this was due to the more recent case of Pepper and Hart, which you can see on screen there. So the facts in each case must be considered retrospectively to establish whether the veil, it's sort of a metaphor really for a divider, whether the company should remain separate from the person or whether the veil should be lifted. Obviously removing that separation and then making the individual liable rather than the company. So this is the Pepper and Hart case has definitely challenged the Salomon case as to whether the veil should have been upheld or disregarded. So the legal concept that separates the personality of a corporation from the personality of its shareholders and protects them from being personally liable for the company's debts or other obligations. And we will discuss a little bit later on about lifting this veil. So the decision of the case firmly established the separate legal entity doctrine, also known as corporate personality, and this decision meant that legal entities be treated separately from not only individuals but also shareholders of a company, in turn providing them with all the benefits needed to promote economic liberalism. Obviously, at that time, they wanted businesses, they wanted entrepreneurs and small businesses to be conceptualized and to be incorporated, and this is why this case has received actually a lot of criticism since. So by treating small private corporations as separate legal entities, the doctrine is said to have encouraged fraud and transfer of legal obligations from the individual shareholders to the corporations. A shareholder of a company limited by shares has a limited liability. And so this means that the shareholder is not liable for the acts and as well omissions of the company. So the liability of the shareholder is limited to the nominal value of its shares. So this is because the company has a separate legal personality to the shareholders and therefore separate and distinct liability to any individuals involved in the company. So the corporate veil may only be lifted by courts to impose personal liability on the shareholders in exceptional circumstances. So for example, where there has been any element of fraud or wrongful trading, as we've discussed, where the company has been incorporated as a sham or to avoid any legal obligations or to conceal true facts. So there would be some injustice perpetrated by refusing to lift the veil, or where there is specific legislative provisions that extend liability to related entities. Yeah, so as you can see on screen, shareholders have two types of liability, limited by shares and by guarantee as well, but we will look at this in depth in a few more slides. So an individual or group of individuals can own shares in companies and other legal entities, but do not necessarily own the entities themselves. So this reiterates that company assets belong to the company and not shareholders. So some duly incorporated entities may not be owned by individuals nor by other entities. So they exist without being owned once they are created. So not being owned, they cannot be bought and sold effectively. So mutual life insurance companies, credit unions, foundations, cooperatives, non-profit organizations, public corporations are all examples of this. So no individual can purchase the company as their ownership is not legally available for sale, neither as shares nor as a single entity. This was established in Cora and Northern Assurance Company. So the facts of the case are as follows. So this case appeared before the House of Lords concerning the principle of lifting the corporate veil. So unusually, the request to do so in this case was made by the corporation's owner. So he wanted to lift veil. Mr. Macora owned the Killymoon estate. This was in Northern Ireland, and he sold the timber there to some sawmills company also in Ireland. This was for 42,000 fully paid £1 shares, making him the whole owner, but with nominees. Mr. Macora was also an unsecured creditor for £19,000. He received insurance policies, however, in his own name and not the company's, with Northern Assurance covering for the event of a fire. And 2 weeks later, unfortunately, there was a fire, and Northern Assurance Company refused to pay because the timber was owned by the company, and because the company was a separate legal entity, it held it did not need to pay Mr. Macora any of the insurance money, essentially. So the House of Lords held that the insurance were not liable on the contract, since the timber that was destroyed in the fire did not belong to Mr. Macora, who actually held the insurance policy. It's quite an interesting case, really, of an instance that it can be sometimes beneficial for the two entities to be seen as one. We'll now look at the use of offshore companies as a trading company. So an offshore company may act as a trading intermediary for sales, distribution, or importing or an exporting company as well. So the company would typically buy directly from the manufacturer or wholesaler and arrange the goods delivered directly to the end customer from the place of production or purchase. So this can be of particular interest where goods originate from one country and are sold in another, yet the principal is located in a third country. So an offshore procurement company can be used as a domestic importer to source goods abroad, and the profits on the difference between the purchase and sales price may be accumulated in a tax-free environment. So such profits can then be reinvested into further development of the business without incurring any excess tax liability. That can also be an option for you if you're looking to incorporate a business of your own. So again, we'll look at lifting the corporate veil. So it's also referred to, you may also refer to this as piercing the veil. So an example would be where a businessman has left his job as a director and signed a contract not to compete with the company he has just left for a specific period of time. This is quite common. And if he then goes to set up a company in direct competition with his former company, technically it would be the company and not the person competing. However, it's likely that a court would say that the new company was just a sham and would still allow the old company to sue the man personally for breach of contract. So a court would look typically beyond any legal fiction and look to the reality of the situation, really. And where lifting would be considered just and equitable. We will now look at Wallersteiner and Moir. So Dr. Wallersteiner had he just purchased a company called Hartley Baird Limited, using money from the company actually itself, which was in direct contravention of the prohibitions on financial assistance. At that time, it was still relevant under the Companies Law Act 1948. So he held 80% of the company, and Mr. Moir, he was one of the 20% remainder shareholders of the business. So wanting to expose Dr. Wallersteiner's various dealings, he circulated a letter to all the other shareholders explaining what Mr. Wallersteiner had done was illegal. And Mr. Wallersteiner sued for libel, actually. This was an instance where the veil was lifted and he was sued actually as an individual rather than on behalf of the company. So we'll now look at the roles, rights and duties of promoters and other basic elements of forming a company. So a corporate promoter is also known as a projector. So this is a person who solicits people to invest money into a corporation, and usually when it's in the formation stage, so not yet fully incorporated. So an investment banker, an underwriter or stock promoter may wholly or in part perform the role of this promoter. And promoters generally owe a duty of utmost good faith so as to not mislead any potential investors and disclose all material facts about the company's business. But we'll talk more about this in just a moment. So the incorporation process, obviously there's lots of contracts and forms required to register a company. We will today look at Cyprus just because I'm here right now, and as well this can be transferred to a lot of other European jurisdictions. But obviously, please check the legislation of the specific country that you're looking to incorporate in. So for Cyprus, so you'd have to fill a declaration of company incorporation form. You'd have to get a registered company office address. You'd have to disclose details of all proposed directors, secretaries of the company, and shareholders if you are going to open the company for shares, as well as the Memorandum and Articles of Association. So these forms you can fill out using information such as the addresses and passport details of the proposed directors and secretary of the company, the proposed registered address of the company. You will need a utility bill to act as proof of residency, a recent bank statement, reference letter maybe as well, and the amount of nominal share capital. So essentially how you want the shares to be divided, and if your company is a public company, PLC, there is a minimum share capital of 25,000 euros in Cyprus. A promoter is essentially a person who does the preliminary work incidental to the formation of a company. Generally, a promoter is in a fiduciary relationship with the corporation and as well the shareholders of the company as well. So the promoter must avoid conflicts of interest and exercise reasonable care when he's performing any company duties. So he must refrain from self-dealing or any other type of abuse to take advantage of his position as promoter. So this role of the promoter, it could be a shareholder in the corporation. So if the promoter is the only shareholder, the corporation may, in compliance with the rules as per that jurisdiction, need to disclose the information prior to selling shares to the public. So the statutory definition of a promoter was established in Twycross and Grant, and it was referred to as one who undertakes to form a company with reference to a given project and to set it going, and who takes necessary steps to accomplish that purpose. However, the term promoter does not include those who act merely in a professional capacity, acting on the instructions of a promoter. So, for example, a solicitor, a lawyer, or accountant, something like that. So pre-incorporation agreement is entered into by the corporate promoters who form the company by filing its articles of incorporation. And since the corporation has not yet been formed, it cannot be a party to this agreement. For more information on this, definitely take note of Kellner and Baxter. So processes of incorporation, a know your client KYC or client inquiry form definitely has to be established in the preliminary documents. Obviously, you will have to decide on the type of company that you would like to incorporate. So a public company usually has over 50 shareholders. It can issue shares up to over 50 people. And a private limited company typically has up to 50 shareholders, and it does not offer shares to the public. And limited liability is it can be limited by shares or by guarantee. And you obviously must choose a name for your company. So you can see if your chosen name already exists in the jurisdiction of your choice. Then this is submitted to the registrar of companies, and depending on the workload of the registrar, the the full company formation procedure in Cyprus can take up to 1 month, and this process can be reduced if a name is chosen from a list of pre-approved names, which can significantly speed up the process and is available in almost all European jurisdictions. And essentially, yeah, that's it. So your company will be registered in no more than 1 month. Once all documents have been approved, you will get a certificate declaring your legitimate business. So, post-incorporation, so common requirements after incorporation, so these requirements are for all business types, and they include to file an initial report or a list if your jurisdiction requires it. It is required in Cyprus, but as far as I'm aware, not for all European jurisdictions. So then you must publish notice of the incorporation or formation in local newspapers, again, if required by the jurisdiction. Annual requirements for all business types include filing an annual report and paying any necessary taxes and fees each year, paying any franchise tax or any state taxes, etc. Activation of the company is usually done so by conducting the first meeting of directors. So the board may also elect to address any optional topics during this initial board meeting, in which case maybe the following should be considered: determining whether you will require shareholders in the company to buy or sell agreements, something like this. Other popular topic agendas are deciding who will be authorized to sign on behalf of the corporation, choosing an accounting method. So any financial issues of a corporation, usually they're quite complex, so you should definitely look at hiring some accountant or financial advisor to advise the business about any of these issues, and as well authorize the release of funds for any initial running costs and purchases. So the individuals authorized may wish to write any receipts for any startup costs, any costs for solicitors, office rental, any inventories, etc. This is all very standard terms for the first board of directors meeting. So what if you're not incorporating but looking to move your business to Cyprus? So transferal of a company's seat of incorporation, this is what it's quite commonly referred to as, and many jurisdictions allow foreign companies to change their jurisdiction of incorporation. So the legislation usually permits the transferal of a company's seat of incorporation into or out of the jurisdiction, and this is a process known as redomiciliation, also known as a continuation procedure as well. So with this process, so the company that the jurisdiction that you're looking to incorporate your company obviously must allow redomiciliation. A shareholder resolution is required in order to redomicile. A notification letter must be sent to the registrar of the company, and you must obtain a certificate of good standing. So specifically in Cyprus, you have to appoint a local representative. You must seek approval of the company name before the relocation process takes place. So filing any applications and documents to the Registrar of Companies, and then the Registrar will issue a temporary certificate of continuation. So the process from a practical perspective is really simple, and usually it's really a much more simpler process than incorporating just from scratch, essentially. And in the same way that you would receive a certificate from the registrar for a new incorporation, the final redomiciliation process is marked with a certificate of continuation, and this essentially means that you have successfully incorporated your business in the jurisdiction in somewhere new. We'll now look at legal effects of continuation. So essentially these documents are the memorandum and the articles of a association. So continuation seeks to ensure that the continued existence of the same legal person, and upon issuance of a provisional certificate, the company is deemed to be validly registered as a company for all purposes of law, and is subject to the obligations and is capable of exercising all powers of a company otherwise registered in Cyprus. So the effects of provisional registration therefore arise immediately upon the issuance of the provisional certificate, and there is no difference at law between the effects of a provisional registration and a final or definitive one. So the company's constitution consists of the Memorandum of Association. In some countries, this is referred to as the Articles of Incorporation, and this is the primary document and will generally regulate the company's activities with the outside world, such as company objects and powers. Whereas the Articles of Association, which in some countries is referred to as bylaws, and this is the secondary document and will generally regulate the company's internal affairs and management, such as procedures for board meetings, dividend entitlements, etc. So in many jurisdictions, only the primary document is filed, so the Memorandum of Association, and the Articles of Association remain private. Actually, though, in some countries, both documents are filed, and once you've filed this with the registrar, it essentially means that this is public knowledge and anyone can access this information about your company. And so we'll look a little bit now at shareholder agreements. So it's quite common for members of a company to supplement the corporate constitution with additional arrangements such as a shareholders agreement, whereby they agree to exercise their membership rights in a certain way. So conceptually, a shareholders agreement fulfills many of the same functions as the corporate constitution, so the Memorandum of Association and Articles of Association. However, because it is a contract, it will not normally bind any new members of the company unless they accede to it. So one benefit of a shareholders agreement is that usually it will be confidential, as most jurisdictions do not require a shareholders agreement to be publicly filed. The Memorandum of Association typically will contain the name of the company, the registered office address, any financial liability of the shareholders, any objects of the company, the capital of the company, so any assets and the division of shares. And yes, it can be any anything else really, depending on your jurisdiction of incorporation. And this can be amended by a special resolution of shareholders. So legal documents that must be stored at your company's registered office address is the official register of members, so known as shareholders, directors, secretary, and any other company officers, and official register of charges, any accounting records, company seal, and the minute book, which is just how long, how frequently meetings are taking place in the company, and how long the meetings go on for. A company is limited to acting within the powers set out in this Memorandum of Association. So anything purported to be done by a company which is beyond those objects would be ultravires and void at common law, and therefore any directors acting in this way could be held personally liable for such acts. So ultravires is a Latin phrase meaning beyond the powers. So if an act requires legal authority and it is done with such authority, it is characterized in law as intravires, so essentially within the powers. And if it is done without such authority, ultravires. Acts that are intravires may equivalently be termed as valid, and that are ultravires invalid. And this was established in Ashbury Railway Carriage Co. Limited and Riche. So the objects of this company, as stated in the objects clause of its memorandum, were to make, sell, or lend any railway carriages and any machinery attributed to trains, essentially. And anything necessary to carry out the business of mechanical engineers and general contractors to purchase and sell as merchants timber, coal, and other materials. So the directors of the company entered into a contract with Riche for financing a construction of a railway line in Belgium, and Riche actually sued the company for breach of contract, and the House of Lords held that the contract was beyond the objects as defined in the objects clause of its memorandum, and therefore it was void, and the company actually had no capacity to approve the contract. So the issue here was whether the contract was valid or not, and whether it could have been ratified by the members of the company. Forms of the Doctrine of Ultraviolet in modern company law legislation. So ascertainment of Ultraviolet Act. So to ascertain whether a particular act is ultraviolet or not, the main purpose must first be ascertained, and then special powers for effecting that purpose must be looked at if the act is neither within the main purpose nor special powers expressly given by the statute. And the inquiry should be made whether the act is incidental to or an act is not ultraviolet if it is found within the main purpose, within special powers expressly given by statute to effectuate the main purpose. So it can also be ultraviolet if it was not within the main purpose or any special powers expressly given, and incidental to or consequential upon the main purpose, and a thing reasonably done for effecting. Share capital or stock refers to the portion of a company's equity that has been obtained by trading stock to a shareholder for cash. So in its strict sense, as used in accounting, share capital comprises the nominal values of all shares issued. So that means basically the sum of their par values as printed on the share certificates. So if the allocation price of shares is greater than their par value, so for instance, as in a rights issue, then the shares are said to be sold at a premium, and this is what's known as a share premium, additional paid in capital or paid in capital in excess of par. So commonly, the share capital is the total of aforementioned nominal share capital and the premium of share capital as well. So the Articles of Association can be amended only after a special resolution has been passed between shareholders. And obviously, with the more shares that you hold in a company, the more rights you have over any decisions to be made about the company. And is known as majority shareholder. But obviously, even if you hold few shares, it's still your funds that you've invested into the company. So minority shareholders need to have some rights as well. So in Greenhalgh and Arden Cinemas, this is again a UK company law case, and it concerns the issue of shares and fraud on the minority. So as an exception to the rule in Foss and Harbottle, this essentially gives rights to minority shareholders where otherwise they wouldn't, based on their holding in the company. So Lord Green in this Greenhalgh and Arden Cinemas Limited case held that instead of Greenhalgh finding himself in a position of control, Greenhalgh was a shareholder in a company. So he finds himself in a position where all control has been lost, and to that extent, the rights are affected as a matter of business. So as a matter of law, I'm unable to hold that as a result of the transaction, the rights are varied. So they remain what they always were, a right to have one vote per share, equally with ordinary shares for the time being issued, which include the new two's ordinary shares resulting from the subdivision. So essentially, where any ruling that's passed is oppressive or prejudicial to the minority, then essentially they can appeal the case, appeal the ruling, and have their rights and have their shares looked after as well. In matters involving a company's lien on shares, this is essentially rights to dispose of property. So share forfeiture is the process by which the directors of a company cancel the power of shareholders if they do not pay their shares on time or when the company demands it. So a company can give 14 days notice to the shareholder, and after 14 days, if the shareholder does not pay, then the company will forfeit his shares and strike off his name from the register of shareholders. So a company will also not pay any received funds from the shareholder. So in order to do a share forfeiture, the Articles of Association of the company should contain provision for this. Okay, so that concludes today's webinar. Thank you so much for participating and submitting your questions. You can find recordings of today's webinar at eltoma-global.com, as well as a place where you can request any future webinars and yeah, see past presentations and recordings of old ones. Okay, so I will reply via email to the questions, and yeah, thanks again everyone. Have a really nice rest of your day.